2255 has some harsh limitations. You know, there's a short statute of limitations. There is preclusion of second and successive petitions for the most part. You know, can't you imagine that defendants who face those limitations, and they filed their 2255 motion 3 days late or something like that, that this would then be used essentially as an end run around those prohibitions?
Your Honor, I don't think it would be an end run precisely because a 3582, even if you do claim an error, will not necessarily be granted. It will be difficult for that. And I agree with Your Honor that there are harsh limitations associated with 2255, and Congress has stated that those limitations are appropriate, but it doesn't mean that in every case, as applied to every defendant, that those limitations are fair. And under certain circumstances, if a defendant misses a limitation by 3 days, he may not be able to challenge his conviction, but he should at least be able to argue this unfairness, the error and the unfairness of him not having been able to bring it under 2255.
I suppose what I'm suggesting is that, Congress, for better or for worse, made a determination that those are the limitations that it wanted. And even to the extent that a judge thinks that they're unfair, in all cases, in most cases, that I doubt that Congress meant for individual judges to override its own judgment.
Absolutely, Your Honor, and that's certainly a limitation that should be placed on 3582, that a judge cannot simply second-guess a decision made by Congress. But even where Congress creates a generally applicable law, such as a mandatory minimum, it doesn't mean that Congress even believed that in every case that would be fair to the defendant. And all we're asking for is that a judge can consider that the way the law has been applied to this defendant has been unfair or even potentially erroneous.
And I thought in